Hello, Assalamu alaikum. Today we are talking about Iraqi family law concerning that, first of all, that we should say that this law, the rules of this law, it's applying to all Iraqi citizens. There is no exception unless there is conflict between laws. So we are going to analyzing some issues that the rules of family law, talking about personal status law, dealing with all this issue concerning marriage contract and other issue such as inheritance or custody of children, and also divorce and other cases. So let's start analyzing the Articles 1 in personal status law, the Iraqi law. This article talking about the legislative provisions of this law shall apply to all matters addresses by these provisions in word, content, letters, and spirits. So according to this article, paragraph 1 and also paragraph 2, so if there is no legislative provisions that can be applied, then the principle of Islamic Sharia most appropriate to the provisions of this law shall be applicable. So here, according to this Article 1, paragraph 1 and 2, if there is no rules to the court to apply in cases, so the principles of Sharia is the most appropriate to considered by the family court in Iraq, the principle of Sharia, according to paragraph 2. So let's move to paragraph 3. The court shall be guided in all this by the provisions adopted by the Islamic judiciary and jurisprudence in Iraq and other Islamic countries with the law that would be covered with the Iraqi law. So we can understand that there is some specific situation that if the judge cannot finding, if he refer to the rules of law, if he cannot find solution and specific provisions and rule, so the judge in that case refer to the principle of Sharia and the principle of the jurisprudence of Islamic scholar. Okay, and this is true. So if we're moving to Article 2, paragraph 1, the provision of this law shall apply to all Iraqis unless they have been exempted by a special law. So the rules of the family law, personal status law, apply to all the Iraqi citizens. For example, if there is another citizen, so the judge considers the law for the other citizens. So here it might be happen that it would be a conflict between two laws. So this is taking consideration that it happened not just in family law, but also in other laws, such as in civil law or in criminal law. So we are going to talking about, for example, to the conflict, for example, and we can find the solution just like standing on the principles of private international law, we can find solution in that case. But if we are talking about the religion, so of course the Muslim is subject to the family law, to the personal status law, basically. And about the Christian, the solution is in the civil court, not in the personal family court. So which is of course a specialist to apply the personal status law. So just in that case, if there is another religion, so we have a special rules that the civil judge can find the solution for all matters happened. Let's moving to the paragraph 2 in Article 2, which is talking about if there is conflict between laws, so we will find the solution specifically according to Article 19, 20, 21, 22, 23, and 24 of the Civil Code shall apply if there is a conflict between laws. And this is what I mentioned previously, that the solution in civil court in that case. If we move to marriage contract, which is in chapter 1, marriage and engagement, there is definition in personal status law in Article 3, paragraph 1. It's talking about marriage is a contract between a man and woman. So there is definition, specific definition, who's lawfully permissible to him to the purpose of which it's found a bond, procreate and live together. So it defined the contract married as a contract between a man and woman, and should be man and a woman, and lawfully permissible to him, the purpose of which is to found a bond, procreate, to live together. So it is about the reason for concluding the contract, and this is very clear. Paragraph 2 in this article also mentioned the marriage consummated. Both parties must abide by the provisions required upon the establishment. And this is also, it's very clear that we just, we just mentioned the consummated of the marriage contract after concluding the contract. And very significant point considered the promise to marry, according to paragraph 3 in this article. The promise to marry, or the reading al-Fatiha, recitation Fatiha, we cannot, according to this paragraph, consider it as a marriage contract. So it's clear say that the promise to marry and recitation of the Fatiha and engagement shall not be considered a marriage contract. And this is what we say it and we mention it. And paragraph 4, it's also very important point in paragraph 4, which is about polygamy in Sharia law, and it's coming to personal status law and the rules. Polygamy is not allowed without a judge permission. So there is no polygamy outside the court and without permission of the judge to give permission to the following condition must fulfill the condition that is in according with the rules of personal status law. So the husband must have financial sufficiency to support more than one wife, and also there is legitimate interest. So it's up to the judge to give this permission. If the judge see the efficiency of the husband, we are talking about the ability to marry another woman financially, and there is interest for the man who apply for other wife. And also, if there are concern on an injustice between among the wives, polygamy is not permissible, and the matter is left to the discretion of the judge. So at last, it's up to the judge to give this permission to the man.